in the last class, we were discussing about the consultancy agreement. So we'll continue with that. Let me share my screen. Yes, again. Diagram. Is my screen visible?
No, ma'am.
Okay. Second. Share. Is it now visible?
Yes, ma'am.
Okay. So we were discussing about the consultancy agreement. Now, quickly, let's go through what is the consultancy agreement. Any one of you remember what is consultancy agreement? Who are the consultants? Quickly give me the definition of the consultants and describe what is consultancy agreement. Then I'll move on to the clauses. Yes. Yes, class, please speak up. Bhavya. You can write in the chat box also if you're not comfortable speaking. Guys, I'll not proceed if you will not answer. Is there anyone who was not in the previous class, who has not attended the session?
Ma'am, there's some. Bhavya has raised her hand.
Okay, Bhavya, you were not in the last class. You want me to repeat the terms? You want me to go through the consultancy agreement and consultants definition and all?
Ma'am, she has written in the chat box. Yes.
Okay. Okay. Just give me a second.
Ma'am,
Yes.
ma'am, a consulting agreement is a legal contract between a consultant, also known as a freelancer or independent contractor, and a client. So, ma'am, the client can be a hiring party or the buyer.
Right.
Yes, ma'am. Yes, ma'am.
Okay. Very good, Lakshmi. I'll just go through whatever we have covered about the consultancy agreement in the last class, and then we'll proceed with the drafting. Just give me a second. So yes, my screen is visible, I guess. Please
Yes,
confirm.
ma'am.
Okay. So today we'll be dealing with the consultancy agreement or consulting agreements. So what are the consulting agreements? A consulting agreement is a contractual document that describes a working relationship between a businessman and a consultant. This can be a businessman or any individual or any individual. And a consultant providing that company or that individual with their services. Other terms that are used to refer a consulting agreement include business consulting agreement, independent contractor agreement, freelance consulting agreement, and so on. So basically, what is consulting agreement is a contract between a person who has his expertise in a particular field and a client who wants those services. Getting my point? The consulting agreement explains the terms of a professional relationship as a method for keeping both the parties accountable when it comes to a type of work and compensation expected. Having a consulting agreement when contracting the services of an outsider advisor or specialist is a standard part of running a business and helps protect your company from possible disputes. Now let's delve into the definition of a consultant. A consultant is an outside professional who provides expertise and advice to improve a business's operations in some or the other way. They analyze the current business behavior, identify the areas for improvement, and develop a plan for improving that aspect of the company. Consultants may also train other staff members and oversee the implementation of a new business tactics, evaluating the outcome and making adjustments as needed. So if you suppose you have a hotel under your name, and you want someone to come and look over your operations and increase the profit, so you will hire an operation management or an operation manager or who is expert in operations. Then he'll come, he'll be your he'll train your staff accordingly, he'll see whatever is your import and export, and then accordingly provide you with strategies to improve your business. Getting my point? This is basically an agreement between any person who has his expertise in a particular field and the other individual, which is the client. Suppose we are legal consultants. So anyone who wants our services in a long term will enter into the legal consultancy agreement with us, and we will be providing our legal expertise, our legal services, our legal advices to that person, to the client, on the contractual basis, whatever terms and conditions are agreed between us. Okay? Bhavya, I hope now it's clear. Okay, thank you, ma'am. Okay, okay. So now let's move on to the terms. So these are some of the important clauses which are there in a consultancy agreement. First is engagement and services. Why are we engaging a person? Why are we engaging a consultant? What are the standard of services which he is required, which he or she is required to provide? Is it an independent contractor status or an dependent contractor status? Then comes terms of services. Terms of services will include non-exclusivity or exclusivity depending on the understanding between a client and the consultant. The termination clause, what will be the effect of termination? Then comes the essential part, which is fees. Fees is divided into two parts, which is the consultancy fee, a fixed remuneration or the retainer fee, and the other miscellaneous expenses. Then comes the duties, or say the responsibility, or say the commitment of the consultant. What will be the duties of the consultant? What will he provide during the tenure or term of this agreement? What will be the duties of the client? What is client obligated to provide the consultant for him to do the task? What is confidentiality? What all will come under the confidentiality clause? What is non-disclosure of negotiation? Ownership of materials, indemnification, representation and warranties, and then the boilerplate clauses. Okay. So in the last class, we have already discussed about the introductory clause. Let's go through it once again. This consultancy agreement, which is known as agreement hereinafter, is made and executed at so and so date on this date of at so and so place on this particular date of January 2024 and shall be effective from this date. Okay. By and between. Now in by and between, you will write who is the consultant and who is the client. Here I have written Rajendra Singh Saini, son of so and so, resident of so and so, hereinafter referred to as consultant. Thereafter comes the client, Chapura Hotels and Resort, having its registered office at so and so place, hereinafter referred to as client. Now, the party here will be individually the consultant and the client will individually be referred to as party and collectively as parties. Now, this is the recital clause. We have already discussed this clause in the last class, but let's go through it once again. The consultant is an expert in the field of goods and services tax, which is hereinafter called as GST, and is engaged in the business of providing consultancy services to other individuals and businesses, helping them comply with GST regulations, file GST returns, and manage their GST related finances. So basically, the consultant over here is an expert in GST. He is providing all the services related to GST, which is GST filing of GST returns, managing of GST related finances, compliance of all the GST regulations. Now, we as a client are hiring or engaging the consultant for our hotel, which is Shapura Hotels, to manage all the GST related business and to comply with all these regulations within time. Now comes the second point. Based on the representations made by the consultant as to its qualifications, expertise, and experience to perform the work and services, more specifically specified and written down in Annexure 1, the client has shown its willingness to engage the consultant for performing the work to be done as mentioned in Annexure 1. So now we have included all the scope of work as Annexure 1 because it was a detailed one. So it's better to have it in the form of annexure to keep it precise and clear. Now, the consultant has acquainted itself qua the scope of work and the requirement of client and has agreed to render its professional consultancy services to the client upon the terms and conditions agreed hereinafter. Now, the consultant has acquainted itself with all the scope of work. Client has elaborated whatever he requires from the consultant, and consultant, after going through the scope of work, has agreed to render its professional consultancy services to the client as per the terms and conditions recorded hereinafter. Let's go to Annexure 1 first. Now, Annexure 1 includes the scope of work. What all work will come under the duties, what all functions will be performed by the consultant. Consultant will perform the following duties, functions, roles, and render these services as under. First, he'll prepare and timely file the annual GST return. He'll file monthly GST returns. He'll ensure that all the relevant details are provided as per the GST rule. He'll identify and rectify if there are any discrepancies in filing. He'll provide the original receipts and proof showing the compliance has already been done. He'll review and classify transactions under the correct HSN SAC codes. He'll review the tax invoices, bills of supply, credit notes, debit notes, etc. He'll review and reconcile data to ensure accuracy. He'll conduct a review of and all the other services. There is a long list of services which he will be providing, which usually a GST consultant provides. These are the services which usually comes under the scope of GST consultant. So the GST consultant shall be responsible for the entire spectrum of GST consultancy services, covering the compliance assessment, classifications, document review, annual returns, input tax credit optimization, advisory, and technology integration. This encompasses all the facets essential for efficient GST management and optimization under this agreement. Any doubt till here? Any doubt? Okay. Now, first clause talks about the engagement. What is basically the client wants from the consultant? The client engages and retains the consultant as client's non-exclusive consultant for all its GST related work and services in respect to its hotel business and to perform all the GST compliances and services, including without limitations to the services enumerated in non-exhaustive list contained in Annexure 1 attached here to, which is hereinafter defined as the services. The client retains the right and discretion to alter, amend, remove, or add to the services specified in Annexure 1 upon the prior written intimation to the consultant. In such an eventuality, the client shall issue and the consultant will sign a notice of change in respect of any such change. Now, what is this clause speaking about is first that the client has engaged the consultant as a non-exclusive consultant. Tell me, what is non-exclusive consultant? What do you understand by non-exclusive consultant? Please don't drop any messages in the chat box. Just unmute yourself and speak out. What do you understand by this term non-exclusive consultant?
That there can be multiple consultants.
Yes, right. Who gave the answer? Okay. So yes, non-exclusive consultant over here, what we are doing, we as a client, we represent the client. So client is engaging the consultant, but he is not restricting itself to this particular consultant. He is free to seek advice of the other consultants as well. If he finds anything which is mysterious, or if he wants to take other person's advice in GST filing or GST compliances, he is free to do that. So non-exclusive consultant herein refers to and gives a bit of flexibility to the client to refer and consult the other consultants as well. The client engages and retains the consultant as a client's non-exclusive consultant. So first this. Then what all services? The services which are provided already as Annexure 1. Now this Annexure 1 is only an illustrative list and it is not an exhaustive list, which means that there can be other services as well. So consultant hereinafter is basically liable to do all the duties which he may require to fulfill the GST compliances for our client. It is not so. This word non-exhaustive list, this word in itself explains that you are not restricted to do only the tasks which are enumerated under Annexure 1. In fact, you are here, we have engaged you to do all the work which is required to fulfill the GST compliances as per law. Getting my point? Then comes the client retains the right. Now here the client has also retained its right to further add, remove, or alter the services specified in Annexure 1. If a client wants to add some services, or if he wants to remove some services from there, suppose he is consulting some other consultant for GST filing, annual GST filing, and he wants this particular consultant to be engaged only for the monthly GST compliances. So he can remove that annual thing from the list. But for doing that, he has to give a prior written intimation to the consultant and receive his notice of change, which is known as NOC hereinafter. Okay. Then comes standard of services. All the services to be provided by the consultant shall be performed with promptness and diligence in a workmanlike manner, ensuring compliance of GST rules and regulations along with necessary documentation. The consultant shall demonstrate a level of proficiency commensurate with its background and experience in GST matters. The client shall provide the consultant with access to relevant information as may be reasonably required to facilitate the performance of GST compliance services. Furthermore, the consultant shall have its authorized representatives available in person, via telephone or via email during normal business hours to address any GST related matters or inquiries. So this clause basically tells about what will be the standard of the services which GST consultant will provide. He will work promptly, he will work diligently, he will ensure that all the rules and regulations along with necessary document are fulfilled. He will provide a telephone and email services for the client, so that if in case client wants to inquire anything about GST related matter of his or her hotel, he can immediately contact the GST consultant's firm or that concerned authorized representative, that particular person, via phone, via email, and can get his queries be solved then and there. Then GST consultant will remain commensurate with its background and experience in GST matters. He will stick and he will perform the functions as per his experience as has been represented to the client before the agreement. Okay, any doubt? Let's move on to the next clause. Representation and warranty. Now the consultant represents and warrants to the client that it is under no contractual or other restrictions or obligations which are inconsistent with the execution of this agreement or which will interfere with the performance of these services. Now here the consultant is representing and warranting. Basically, he is giving a warrant to the client that he is neither under any contractual obligation or under any restriction by any other person or through any other agreement which will interfere his performance of the services for our client. The consultant further represents and warrants that it possesses the requisite manpowers, resources, expertise, and experience to effectively carry out the obligations related to this particular GST compliance under this agreement to the satisfaction of the client. Now, this is pretty simple. He is just representing and warranting that he has all the staff, he has all the resources, and he has well experience to effectively carry out all his obligations, whichever is required to fulfill to the satisfaction of the client. Then comes independent contractor status. What do you understand by independent contractor status? Independent contractor status?
That the contractor is not part of any organization or other, but
Sorry?
but that the contractor is working individually here.
No, basically this means that independent contractor status here means that this particular contract is between a consultant and a client, and any other contract which the contractor may have entered will not bind the client. Okay, will not provide or not delve any authority or any obligation upon the client. So this particular contract is independent of any other status. The consultant acknowledges and accepts that it shall provide GST consultant services as an independent contractor. The consultant shall not at any time enter into any contract with any other person, firm, or corporation that purports to bind the client. He can enter, definitely, he can enter into any other agreement, but that agreement should not bind the client over here in any manner whatsoever without written authority from that client. Any such contract entered into by the consultant shall not be binding upon the client. So if a contractor has entered into any other contract with some other client, then all he wants to ensure via this clause is that the client's work will not be hampered and client will in no way be bound by that separate contract. Okay. The consultant specifically acknowledges and accepts that the client shall not be bound by anything done by the consultant purporting to the act under this agreement, which is not pre-approved by the client. Now, if there is anything in this agreement which client has not approved and consultant is doing on its own will, then the client is not liable for any such act. The client reserves the right and discretion to reject any contract or commitment related to GST consultancy services without the need for furnishing reasons to the consultant. So if in case any non-approved task is being done by the consultant, then client herein reserves his right to reject this contract or reject any such commitment which the consultant has given without furnishing any reasons to the consultant. Any doubt? Okay, let's move on to the next clause, which says the term of services. Now, this is simple clause. I want you guys to draft this clause and drop it in the chat box. Term of services. What will be the term of services and what all clauses will come under the term of services? We have discussed this term for license agreement, for leave agreement, and for other agreements. So I want you to draft this clause. Guys, there are more than 12 students who have joined. I want at least 50% to answer. No one wants to answer? Okay, I'll wait for 1 more minute and then I'll proceed. But this is not how you will learn. If you will not draft, then you will not learn. This is not a literature. Okay, I'm proceeding further. So, terms of services. The client hereby engages the consultant and the consultant accepts to render the services for so and so months. So this is basically a term clause. It will only include that the client and the consultant hereby agrees to accept and render the services for so and so period, which will start from the effective date and which will end at the end of this agreement or unless terminated earlier in accordance with this agreement. The consultant is responsible for achieving the specified GST deliverables to the client's satisfaction, and its performance will be reviewed periodically with a schedule to be mutually agreed upon. So this is something subjective. You can include this to protect your client's interest, that the consultant is responsible to give the GST deliverables as per client satisfaction, and his performance will be reviewed at a specified intervals of time. The term of this agreement may be renewed following a written notice or email of such renewal by the client and the acceptance thereof by the consultant upon the terms and conditions as may be decided between both the parties. Now, this term can also be renewed, but via written written notice, or an email which is accepted between and by both the parties. Now, the client and the consultant shall evaluate the progress of the services to be provided under this agreement at regular intervals and take corrective measures as may be required to ensure the effective compliance with the services promised by the consultant. Now, here is this particular clause which talks about the periodic review. So at regular intervals, the work of the consultant will be reviewed by the client, and if it requires any corrective measures, that measures will be duly intimated to the client. That queries, that difficulties which is being faced by the client will be duly intimated to the consultant, and consultant will accordingly take the corrective measures as may be required. Then comes the non-exclusivity clause. Now, we have already discussed this. Let's go through it once again. The client acknowledges that this agreement does not impose an obligation to exclusively engage or seek advice regarding the services rendered by the consultant. So this is a non-exclusive consultancy agreement, and client is not bound by this agreement, and he's free to seek the advice of any other consultant he may wish to. During the term of this agreement, the client reserves the right to engage or seek advice from other parties regarding similar services without any restriction or prior intimation to the consultant. Then comes the termination clause. Now, if in case there is any difficulty which is being faced by the client, he can terminate this agreement. This agreement may be terminated by the client without cause by providing a written notice to the consultant designated email address or any other designated email address as communicated for the purpose in writing at least 15 days in advance of the termination. Now, if in case clients want to terminate this agreement, he can do so with cause or without cause. If there are reasonable cause, then also he can terminate. And even if there is no cause, he is free to terminate this agreement as per his discretion. But for that, he has to provide a written notice to the consultant. The parties hereby mutually agree that the client shall have the exclusive right to terminate this agreement by written notice or email to the other in event of material breach of the agreement by the consultant. If the consultant breaches any of the terms or conditions enumerated herein in this agreement, then the client has the exclusive right to terminate this agreement, which has not been addressed or rectified within 30 days of written notice or email to the consultant. So here, by including this clause, we are protecting the right of the client as well as of the consultant that yes, if there is any material breach of any of the terms or conditions, then the client will first provide a notice to the consultant, who will try his best to rectify and address the issues raised by the client within a period of 30 days. And if he is unable to rectify or address the issues raised by the client within this period, then the client has full right to terminate this agreement by providing a written notice to the consultant. The consultant acknowledges that it shall not have the right to terminate this agreement without
Ma'am, you aren't audible.
Not audible, ma'am.
Can anyone please let me know till where have you guys followed? I was not aware that I've lost my network. Anyone? Just let me know till where have you followed.
Ma'am, before 2.1 till 2.5.1.
Okay. So sorry. 2.5.1. Okay. This agreement may be terminated by the client without cause by providing a written notice to the consultant designated email address or any other designated email address communicated for this purpose in writing at least 15 days in advance of the termination. So now here the termination clause, client is having the right to terminate this agreement without any cause, but the consultant on the other hand is not having the right to terminate this agreement without any particular cause. Okay. So if a consultant wants to terminate this agreement, he has to specify a particular cause for that. And if a client wants to terminate the agreement, he can do so with or without cause. But if he's having any problem with the consultant, or if he finds that the consultant is not fulfilling the duties as enumerated in this agreement, he will provide a notice to the consultant to rectify or address the issues. And thereafter, if the consultant fails to rectify or address the issues raised by the client, then the client is free to terminate this agreement via written notice or email. Let's go to the clause. This agreement may be terminated by client without cause by providing a written notice to the, we have gone through this. The parties hereby mutually agree that the client shall have the exclusive right to terminate this agreement by written notice or email to the other in the event of material breach of agreement by the consultant, which has not been addressed or rectified within 30 days of the written notice or email to the consultant. Any doubt? Any doubt in the clause? Okay. The consultant hereby acknowledges that it shall not have the right to terminate the agreement without any reasonable cause. Now, if consultant wants to terminate this agreement, he has to give a reasonable cause to the client, and then if the client agrees to that cause, the agreement can be terminated. What will be the effect of termination? Suppose if the agreement gets terminated prior to the expiry of the term, what will be the effect? Upon the effective date of termination or expiry of this agreement, all legal obligations, rights, and duties arising out of this agreement shall terminate, except for such legal obligations, rights, and duties, including without limitations the performance of services as shall be accrued prior to the effective date of termination, and except as otherwise expressly provided in this agreement. So now, if in case this agreement gets terminated prior to the expiry of the term, then the consultant will be under legal obligation to fulfill all its right and duties which have generated prior to the expiry or prior to the date of termination. Suppose this agreement gets terminated around 25th of May, right? And GST filing, monthly GST filing was to be done on 28th of May. Then the consultant will be legally obliged to complete that May portion, May obligation, and fulfill and file the GST return for the month of May for the client. And suppose this agreement is terminated on 26th or 27th of May, then the client will also be obligated to provide the retainer fee of that particular month to the consultant. Okay. Without prejudice to the generality of the foregoing, the consultant hereby undertakes to complete all the pending assignment and works being performed to be performed by it for the client hereunder prior to such termination, and undertakes to continue to perform all the services of the continuous nature till the termination becomes effective. The client agrees that in the event of termination of this agreement by it shall clear all the outstanding dues, if any, subject to the consultant fulfilling its duties and obligations as enumerated hereinafter in this agreement, and stipulated date of the fulfillment of which was assumed to be before the effective date of termination. So I have already discussed this. If you have any doubt, you can ask me. Additionally, if the consultant has failed to complete the services as per the terms of the agreement, then the client shall have the right to withhold the retainer fee of the consultant for that respective month in which the services was not successfully rendered. So suppose the agreement is terminated by the consultant prior to 1st of June and the consultant has not fulfilled its obligations for the month of June, then the client has complete right to withhold the retainership for the month of June till the time consultant fulfill its all obligations which were due for that particular month. Upon the effective date of termination or expiry of this agreement, the consultant shall immediately cease to use all the confidential and exclusive information provided by the client. This is very important. As soon as this agreement will come to an end, the consultant will cease to use all the confidential information which was provided by the client. This information includes but is not limited to all the financial records, documents, and other details. Within 7 days after the termination or expiry of this agreement, the consultant shall return to the client all the confidential and exclusive information related to the client, including the physical and digital reproductions. All these clauses are very important because these are the clauses which further raise disputes, give a rise to the disputes. Alternatively, with the client's prior written approval, the consultant may securely destroy, erase such information from its record. Again, important, very important clause, that as soon as this agreement will come to an end, consultant will destroy and erase all the information of the client, because all these information are very confidential, and hence the consultant is under a legal obligation to erase all its record as soon as this agreement comes to an end. The consultant shall furnish a certificate of confirming the complete return or destruction of the aforementioned information to the satisfaction of the client upon client's written request. All these clauses are here to protect that our client is safeguarded in all the manner, and the information of the client is not used in any of the illegal manners by the consultant. Okay. Then comes retainer fee and expenses. Is there anyone who wants to give it a hand and try to draft this clause? This is again a very simple clause. Is there anyone?
Ma'am, I would like to know whether how to know that what are the best practice to know this consultant's agreement is the comprehensive and this will be enforceable in the court.
So that is very subjective. Now, few of the important clauses which I have highlighted, right? You must always ensure that your client's interest is safeguarded. Now, how will your client's interest will be safeguarded? First, to ensure that all the data which he is giving to the consultant is safe, is confidential, and is not shared with any other third party, either during the term of the agreement or thereafter also. First thing. Then you will see what will be the retainer fee, what all clauses will be there if in case consultant breaches particular term. All this is very subjective, but there are few clauses which you will always include in order to safeguard your client's interest, which I have highlighted. Okay. There's nothing, if you are having any of the agreement which is agreed and signed by both the parties and is properly executed with the notary and on the stamp paper, it is always enforceable in the court.
Okay, thank you.
Yes. So anyone wants to try retainer fee and expenses? Want to try and draft this clause? Otherwise, I'll move forward. No one is willing to draft today. Okay. Now today I'll give you guys an assignment, and tomorrow's class will be on that particular assignment only. Retainership fee and expenses, consultancy. Now I have divided these this retainership fee in two parts. First is consultancy fee and the other is expenses. Now this is fixed remuneration which the particular consultant will get, and these are the expenses which the other party may raise as per the actual expenses incurred by it. First is the consultancy fee. In consideration to the services to be rendered here under, the consultant will be entitled to a lump sum amount of so and so per month to be paid to the client. Again, this will be inclusive of all the other applicable charges and taxes, if any. The consultant shall issue an invoice for the retainer fee at the beginning of each calendar month, and the client shall promptly make the payment subject to the successful completion of the work. Again, subject to the successful completion of the work is important. Now, client is obligated to make the timely payment, but that is only subject to the condition that the consultant has fulfilled all its obligations. Any delay or non-completion of the services by the consultant shall entitle the client to withhold the retainer fee till the time such services are made good. Again, an important clause, how to safeguard your client's interest, that the client has a right to withhold the retainer fee if in case the consultant has not fulfilled its services. Then comes the expenses. Whatever the miscellaneous expenses will be there by the consultant, he can raise the bills to the client or he will bear those expenses by himself. Again, this is very subjective. Either the client and the consultant can have an understanding that client will be responsible to reimburse all the miscellaneous expenses, or consultant will himself bear all the expenses. Now, let's see here. The consultant shall bear the responsibility for and cover all the reasonable expenses necessary to effectively provide the services under this agreement. If the client agrees to reimburse any such expenses, they must be pre-approved by the client. The consultant will only be entitled to the reimbursement of pre-approved and reasonable expenses incurred in the performance of GST compliance services. Reimbursement shall be subject to the submission and approval of written statements and receipts following the consultant's regular procedures. Now here, first the consultant hereby agrees that he will bear all the expenses, and if in case there are any other miscellaneous expenses over and above the expenses which are usually occurred, then he may raise those bills with the client, but those should be pre-approved by the client. Payment by the client for the retainer fee and approved expenses, if any, shall be made within so and so business day from the date of receipt of original invoice. Then the payment by the client to the consultant for the amount of GST output liability and GST returns filing are to be made to the GST department shall be made full in advance within 7 business days from the date of receipt of the original invoice. And there is nothing to explain in this. Then again comes the duties which we have already discussed, that he will fulfill the scope of work. This is the major duty of the consultant. He will do all the filings and he will provide the receipts and proofs of those filings to the particular client. Then come what will be the duty of the client. The client's duty will be to make all the payments on time and thereafter to provide all the supportive documents which are required by the consultant to fulfill his obligation under this agreement. The client assures that all the undisputed payment as and when demanded by the consultant as per clause 3 of this agreement shall be released by the client promptly. The client shall provide all the necessary information, material, time, and other support that is deemed fit to help the consultant carry out its obligations. Then comes the confidentiality clause. We have already discussed about this confidentiality clause, that all the information which the client is sharing with the consultant is very confidential and should not be shared to any third party, either within the term of this agreement or after the term of this agreement. And if in case consultant does any such act, then he will be liable to compensate for that. Let's go through it. The consultant shall keep confidential all information of a confidential or proprietary nature, whether oral or written, relating to the aspects of the client's finances, including without limitations, client's income, expenditure, return, budget, pricing, turnover, trade secrets, know-how, etc. that comes in our possession, whether directly or indirectly, as a result of which or in connection with the services under this agreement. The consultant acknowledges that its breach or threatened breach of any provision under the headings confidentiality will cause the client to suffer irreparable harm that cannot be calculated or fully or adequately compensated by the recovery of damages alone. Again, an important clause which is herein incorporated to protect the client's interest. Accordingly, the consultant agrees that the client shall be entitled, in addition to or any other relief available to it in law or equity, to the granting of injunctive relief without proof of actual damages or requirements to establish the inadequacy of any of the other remedies available to it. The consultant covenants not to assert any defense in proceeding regarding the granting of an injunction or specific performance based on the availability to the client of any other remedy. Now here the consultant has agreed that if in case he breaches this confidentiality clause, then the client will have the right to head to the court for the relief of injunction, apart from the actual damages which he has suffered. The client asserts exclusive ownership of all the confidential information. Now here, client is the exclusive owner of all the documents which he is sharing. He is sharing these agreements with the consultant only for the purpose of this services and is not transferring the ownership of these documents to the consultant. Consultant shall keep confidential the terms of this agreement. Now again, the consultant is not only required to keep confidential the information which he is sharing, but also the terms of this agreement. Client shall keep confidential exclusive tools, processes, and information belonging to the consultant. Now again, here the client is also obligated to keep confidential the tools which the consultant or the processes which the consultant is using to fulfill the duties. The consultant shall provide the client prior approval before utilizing any of the client's personal or financial information for the purposes essential to the successful completion of the work. Now, the consultant, before utilizing any of the client's personal or financial information, will give a prior intimation or take a prior approval from the client to use those information. Non-disclosure of negotiations. Each party agrees not to disclose the existence or the contents of this agreement to any third party without the prior consent of the other party. Except, what are the exceptions to this? We have already discussed that both the parties are obligated not to disclose the terms of this agreement because these are confidential. So, in case it is required under the law or by court order or by any of the auditor, then in such case, they can disclose the terms if required. Ownership of material, already discussed that the consultant herein agrees that all the information which is being provided by the client is the sole owner of those property or the information which he or she is providing. Then comes the indemnification clause. It is understood between the parties that the services provided by the consultant, including those that are specifically enumerated in Annexure 1 under this agreement, are based on information and instructions passed by the client to the consultant willfully or otherwise. The client shall therefore endeavor to provide authentic and complete information to the consultant. Now, this is again a duty of client to provide all the authentic and complete right information to the consultant. And if there are any loopholes in the information which the client is providing, and for that cause, if the consultant faces any of the legal problem or any of the claims, then client herein agrees to indemnify the consultant for the same. The consultant does hereby undertake to indemnify and hold harmless the client and its affiliate and source for the breach of any of the provisions of this agreement, any act of negligence, delays, or willful misconduct, misrepresentation, or concealment of information. Any third party claim, suit, or proceeding is initiated against the client arising out of consultant acts or services. I guess all of you know the meaning of indemnification. Is there anyone who does not know what indemnification is? No. So basically, what this clause is saying that first, the client is obligated to provide all the information which is authentic and correct to the consultant. If because of any wrongful information which is provided by the client, consultant faces any issue, then client will indemnify him. And on the other hand, if client has provided all the authentic and rightful information to the consultant, and it is the due and consultant due to its negligence has wrongly written those information or has misinterpreted those information or has willfully delayed in fulfilling the services, if for those reasons client faces any of the legal hurdles, then the consultant will be liable to indemnify the client for that purpose. Okay. Then representation and warranties, we have already discussed this. These are in detail. You can go through it and let me know if you have any doubt in any of these representations and warranties. Then comes severability clause. If any provision of this agreement is or becomes invalid or illegal or unenforceable under the laws or of any jurisdiction, then such provision shall be given no effect and shall be deemed not to be included in this agreement, but without invalidating any of the remaining provisions of this agreement, which shall not in any way be affected or impaired. The parties hereto shall then use all the reasonable endeavors to replace the invalid or unenforceable provisions with a valid and enforceable one. So if in case any of the agreement, we have gone through the clauses of this agreement. So if in case any of the provision in this agreement becomes contrary to the law or any of the jurisdiction, then that particular clause only will be replaced and will be made enforceable, will be converted into some other clause which is enforceable, but that will not make the entire agreement as illegal. Okay, entire agreement, that particular clause will have a separable or separate effect and will not affect the rest of the agreement. Survival of the clauses. This is again a boilerplate clause that what all clauses will survive even if this agreement is terminated. These are indemnification clause, ownership of material, and confidentiality clause. Waiver we have already discussed. This is again a boilerplate clause. Completion agreement and variation already discussed. Again a boilerplate clause. Governing law. Governing law will be the law where any of the parties resides or have their business running, or where the cause of action is arising, where the parties are entering into the agreement, that will become your place of arbitration or the venue of arbitration. Then notices and communication. The notices will be served to the parties on their given addresses which are written under this agreement. Anything which you have not understood or you want me to repeat? Any clause, anything? This was all about consultancy agreement. No doubts? Now I'll not be sharing this agreement and I want you guys to draft the consultancy agreement by tomorrow, and then we'll discuss upon those clauses drafted by you. I'm not sharing, and I'll not share this agreement.
Ma'am, we have to draft even the annexures.
No, not required, not the annexures. You can draft a simple consultancy agreement, not this exhaustive, not this comprehensive, a small 3 to 4 pager draft. But I want drafts tomorrow. I will ask you guys to share your screens. I will review it, and then only we'll proceed with any further agreements. Otherwise, I'll not proceed further with any of the agreements, because I am here for you guys only. If you are not participating, you are not ready to draft anything, there's no use. We can go through n number of agreements, but you will not learn this way. Just give it a try. It's a request. Give it a try. Draft a 2 to 3 pager agreement with few of the essential clauses. I'll share that important clauses, the list which I have prepared for the important clauses. I'll share that with you guys, and just try and draft something out of it. Okay?
Okay, ma'am. Ma'am, by what time will be the class tomorrow?
We can keep it either in the morning or evening, whatever suits you guys. Not in the afternoon. Either we can keep it at the same time, 8 to 9, or we can have it in the morning at 10 to 11.
Ma'am, I believe we can have it in the evening since the students will get time to make their drafts as well by then.
Okay. So we'll have it in the evening at the same time.
Okay, thank you so much, ma'am, and thank you everyone who has joined. And I'll inform everyone else as well, ma'am, to make the agreement and share the drafts tomorrow.
Yes, please. Okay.
Yes, ma'am.
Thank you.